Civil Service Commission ruled that port management violated the 60-day rule when it served notice of adverse action against port personnel specialist Francis Areola last year. Areola and 5 other port workers were terminated on December 18th for their alleged involvement in a conspiracy to defraud the government and then cover it up. Areola was accused of altering a travel itinerary and inputting the wrong per diem rate for a travel request and authorization, as well as drafting and backdating a memo to put in a file. Port legal counsel Mike Phillips, however, argued that the 60-day rule was not violated.
And so the question of whether the board knew on the 19th or the 25th, there's no meeting of any minutes or anything that occurred on the 19th. The 19th, the director and deputy were summoned to my office because the chair had discovered that there was an attempt to expend $70,000 of taxpayers' money.
Areola's attorney Daniel Summerfleck took issue that no minutes or recordings had been taken of that particular meeting. He said the violation was clear and read from his client's adverse action.
The reason it took HR from at least October 18th, when the board found out about this illegal travel, to November 19th was to have their story straight. So by their own admission by counsel in the adverse action, not a document additional, but by their own admission in their own findings of facts and conclusions of law, they have admitted the board found out about this illegal travel on the 18th.
Commissioners were convinced that management knew or should have known on October 18th of last year about the facts or events that were the basis for the adverse action against her.
They knew that something was wrong. They knew then, since October 18th, why was not anything done. If they, in fact, can prove that there was defraud, or the government by changing the TA.
All 5 commissioners voted in favor of Areola, who was overcome with emotion and embraced her former co-workers as she left the commission last night. It's unclear, though, if she'll get her old job back, as the port is currently reviewing the CSC's decision, and once a written judgment is signed, they can ask the commission to reconsider and further pursue the matter in the court. The CSC did not make the same ruling, though, for former Port Marketing Administrator Bernadette Stern-Menno, even though her attorney Curtis Vandeveld raised similar arguments regarding the 60-day rule, saying all of the dates referenced in his client's adverse action are all well before October 18th of last year.
Management is not defined as the board. It's not defined as the chairman of the board. As you quite clearly and accurately pointed out, management includes the general manager and the acting general manager and the deputy general manager.
Attorney Phillips said even if the facts of the case have dates prior to October 18th, there was no way the port knew at those times that Menno was committing fraud on her claims.
The fraud occurs when you're trying to get the government of Guam and in our system, the port to pay for it. There's not a single shred of evidence that there was a disclosure to management that what you see today, the miracle cure, was known to Mary or Anisha or anybody.
Menno raised several other arguments about why her adverse action must be dismissed, but commissioners weren't convinced. CSC member John Smith.
Based on all the information we had, Mr. Lahi was authorized by the Board of Directors to take that position and sign the document legally. The delivery of service, I have no question about that. The husband refused to accept it. He knew I believe he knew ahead of time what it was. He refused to accept it. It was left there.
Because they determined that Menno did not meet her burden by a preponderance of the evidence, the commission would now proceed with hearing the merits of her case. Reporting for Guam's News Network, I'm Mindy Egan.